Hey everybody, this one is called Do-It-Yourself Kangaroo Court number 15, Bad Behavior. And these are all examples of bad behavior. When acting to enforce a statute and its subsequent amendments to the present date, the judge in municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, as a bought and paid for clerk, but merely act as an extension agent, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. They're bought and paid for. It is the accepted rule, not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, and that's always, they are described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise, act as bought and paid for clerks of the involved agency. That's called bad behavior. That's not a court. Copies of these documents can be found in my private group at Yahoo called Administrating Your Public Servants. For a complete set of YouTube videos with private information shares, a DVD with over 50 searchable law dictionaries, and other books and forums, contact me privately at engineerwin@yahoo.com. Donations to support this work are appreciated. I prefer gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the PayPal gifts, the checks, the money orders. Send me an email for particulars. Oath. All oaths must be lawful allowed by common law or some statute if they are administered by persons in their private capacity or not duly authorized. They are quorum non judice and void. And this is a cite from Tomlin's Law Dictionary, 1835 edition, volume 2, but they are citing book 3 of the Institutes and the Laws of England and book 4, which goes back to Coke and the 1500s. So the point is that all government officials can be in their official capacity or they can be in their private capacity. An officer who acts in violation of the Constitution ceases to represent the government. If they're in violation of the Constitution, then they're in their private capacity. If they do anything that's illegal or unconstitutional, they cease to represent the government and immediately move from their official capacity to their private capacity. That's called bad behavior. A clerk masquerading as a judge is not competent to do anything judicial like issue orders or warrants. A clerk masquerading as a judge is operating in his private capacity and has no immunity. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. If they spell your name in all block capital letters, they're operating in their private capacity. If they're attacking you with a statute, they're operating in their private capacity. Don't forget to subscribe to this YouTube channel. Don't forget to follow me on Steemit at Sovereignty International. Don't forget to like this video. On YouTube, don't forget to click the bell next to the subscribe button so you're notified when there's a new upload. On Steemit, don't forget to vote and make your comments. And there's the front page of my channel, and notice the subscribe button has already been clicked because it's not red. Normally they would be red. The arrow is pointing at the bell. The bell button in this case has not been clicked because it would look like it's vibrating. You click on the bell, the pop-up will come up, and you have to check the box and click OK, saying that you wish to be notified. This is Steemit. The left arrow is the number of upvotes. The middle arrow is where you do your upvotes, and the right arrow is where you make comments. This is also Steemit. The hand is touching the crypto wallet profile. A little window comes down, and that's where you can follow or unfollow someone. Every taxpayer is assessed to K Trust having sufficient interest in preventing the abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And that's a summary taken from Inri Boland's 1912. A summary of 5 pages of the congressional record dated June 13, 1967 is: a citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust, the constructive Sesticate Trust of U.S. Inc. under the 14th Amendment, which upholds the debt of the USA and U.S. Inc. And this is taken from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mortmain. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Roman cult, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fees to the use of the religious houses. That's the Roman cult, folks. Thus distinguishing between the possession and the use and receiving the actual profits while the season of the land remained in the nominal fee, who was held by the courts of equity, then under the direction of the clergy. That's the Roman cult, folks. That's quite the scam they got going on, isn't it, folks? To be bound in conscience to account to the sesticus for the rents and emoluments of the estate. That's taxes, folks. It's quite the little scam they got going on here, isn't it? And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And it's still the foundation of modern conveyancing. This is the DC Code, located at 31 Stat 1432, and at Chapter 16 or Section 1617, Chapter 56, it says the legal estate to be in the sesticus. And this is more DC Code. This is right up in the front, which was approved on March 3rd, 1901 by the 56th Congress, Session 2 at 31 Stat 1189. And at 2, it says, and be it further enacted in the interpretation and construction of said code, the following rules should be observed, namely, the word person shall be held to apply to partnerships and corporations. This is more DC Code. This is Section 252 at 31 Stat 1230, and absence of 7 years. And it's where they presume you're dead. So they presume that if they're talking to you, it's a sesticate trust. And this is where it's codified. Statutes equals contract equals Roman cult. Did you give up your God-given rights for some satanic privileges? That's Title 15, United States Code, Section 44, definitions. Corporation shall be deemed to include any company, trust, so-called Massachusetts trust or association, incorporated or unincorporated, which is organized to carry on business for its own profit or that of its members, and has shares of capital or capital stock or certificates of interest. And any company, trust, and it goes on to the same definition, but it does not have shares of capital or capital stock or certificates of interest. That's a sesticate trust, folks. Statutes equals contract equals Roman cult. Did you give up your God-given rights for some satanic privileges? But individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights, duties, and privileges of the artificial entity or association of which they are agents or officers, and they are bound by its obligations. That's U.S. Supreme Court, Braswell versus United States, quoting U.S. versus White. And so they are assaulting you with their sesticate trust. That bail priest up in the front of the courtroom that's run by the Roman cult is sitting there presuming that you want to be a surety for their fraudulently created sesticate trust. VidMe shut down on the 15th of December, and YouTube channel called Sovereignty International is deleted. I made the exclusive content available on my website. I have 2 subscription levels, and I accept cryptocurrencies. My basic subscription level is $2.99 a month or $19.99 a year for the videos only. My platinum subscription level is $4.99 a month or $39.99 a year for the videos plus unlimited consultations. Now, there's limits as to what I can do as far as the consultations are concerned. And the limit is that I'm not a liar. Well, I meant an attorney. No, actually, I meant a liar. But I can tell you what I would do under a certain circumstance and where to find the forms. That's the limit on what I can do as far as consultations are concerned. The only power that these New World Order Satanists have over us is through fraud and deception, and my agenda is to expose it for all our benefit. And I cannot fight all the battles. I need other people fighting the battles and being on point and bringing up the right issues. And so If you want to subscribe to watch the videos, then that's great. But if you want to subscribe just to make a donation to support the cause, that's great too. It's a small, moderate donation or modest donation, but a whole bunch of people chipping in a modest donation, it adds up really fast. And so anything is appreciated. And I'm currently publishing one video a week. Some of the exclusive content is Arlington Private Information Share, which is actually about 9 videos by itself. Land deed training, estoppel certificates training, foreclosure estoppel certificates training, corporate denial training, toll roads notice and demand training, invoice training, notice of void judgment training, revocation of signature training, third-party witness training. Federal habeas corpus training, revocation of voter registration training, criminal complaint training, lawsuit training is coming. Okay, there's no lawsuit training yet there, but there will be some coming, and there is some criminal complaint training, but I'll probably be uploading more. Just because of the fact that, things are kind of dynamic in that area and we need to make them as powerful as possible. So when I see something that needs to be brought to your attention, I upload a new one. And there'll be other training based on requests. There has been some requests, although people want to know about how to do bonds and all that. That's really not an area of my expertise, although there is a video that talks about bonds. Everything that is needed to free yourself is available for free on my free YouTube channel, Sovereign Living. All of this training is really above and beyond. It's not that difficult to do this stuff, but if you need some help with it, I'm available in the form of these training videos or in addition to that, if needed, for a donation. And I'll even prepare paperwork, but that I have fees available for that. I have the forms. They're all forms, standard forms that are available on the Yahoo group. All forms, files, and other instructions are available for free on my 2 private groups at Yahoo groups and Google groups. 2 national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independent of that instrument. And that is dissenting opinion of Justice Marshall Harlan in the case Downs versus Bidwell, the U.S. Supreme Court in 1901. So there's the constitutional, the one that operates under the Constitution, and the other one that's unconstitutional. Think about it. It's unconstitutional. It's a corporation. It's a fake government. It's not a government. It's a bunch of pirates and thieves. And if you get mixed up in it, then it's a contract. A state does not owe its origin to the government of the United States in the highest or any of its branches. It was in existence before it. It derives its authority from the same pure and sacred source as itself, the voluntary and deliberate choice of the people. A state is altogether exempt from the jurisdiction of the courts of the United States or from any other exterior authority unless in special instances where the general government has power derived from the Constitution itself. The question to be determined here is whether this state, so respectable and whose claim soars so high, is amenable to the jurisdiction of the Supreme Court of the United States. This question, important in itself, will depend on others, more important still, and may perhaps be ultimately resolved into one, no less radical than this: do the people of the United States form a nation? And this is the most telling part of this site. By that law, the several states and governments spread over our globe are considered as forming a society, not a nation. And that's Chisholm versus Georgia, U.S. Supreme Court, 1794. So the point being, in 1794, there were no nations on this planet except the United States of America. All the rest of them are societies, they're corporations, they're clubs. And when you get mixed up in it, like this, what this dissenting opinion of Justice Marshall Harlan says, it's a contract. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute and the only object is to recover a penalty or forfeiture, such action is a penal action. The words penal and penalty in their strict and primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. A contract, folks. That's exactly what's going on. It's called a quasi-contract. The words forfeit and penalty are substantially synonymous. So when the judge is dealing with all of this, he's in bad behavior, okay? Because he's assaulting you. Unless he just drops this thing and makes it go away for you, he is in bad behavior. A penal action is one founded entirely on statute and brought with the sole object of recovering a penalty or forfeiture imposed as punishment or specific offense, while a remedial action is one brought to obtain compensation or indemnity. Again, if a judge is dealing with this, now notice penal and penalty, like as in Texas Penal Code or California Penal Code, and even in places like Arizona where it's just a criminal code, it talks about penal and penalties. So it's a penal code too, even though they don't want to call it that. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions on the one hand, closely related to criminal prosecutions. On the other, actions for private injuries in which the party agreed may by statute recover damages. Okay, so these Satanist pigs assault you with a civil suit, okay? And so it's a contract. And they just go ahead and assault you. That's why they're called pigs. My blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profile, Sovereign Living, and Sovereignty International has been deleted. I got to fix that. The Facebook community page is deleted. My Facebook private group, Sovereignty International, is being deleted. It takes time to ban 17,000 people off your group, and I'm not going to let Facebook profit from my hard work. They make money by all that work that I did, and I'm going to deprive them of it. My Yahoo private group is called Administrating Your Public Servants. My Google private group is called Administrating Your Public Servants. Follow me on Twitter at Engineer Win. And the VidMe is gone. Steemit. Follow me on Steemit at Sovereignty International. Got to fix that, don't I? A subset, this is talking about quasi-contracts. If you get that clerk, that bought and paid for clerk masquerading as a judge, sitting up there to admit it, he'll tell you that the case is quasi-criminal. Well, that's because it's a quasi-contract. They're assaulting you with one of their so-called contracts. So that's the time you have to bring up fraud upon the court and bad behavior and the fact that it's not a court. A subset. In its origin, an action of tort, the subset was soon transformed into an action of contract, becoming afterwards a remedy where there is neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. See, that's what these liars get. They just go and fabricate all this stuff. Introduced as a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action, which superseded debt. See, they fabricate debt. Became concurrent with account, with case upon bailment, a warranty, and bills of exchange, okay? So it's all contingent upon Federal Reserve notes, upon debt, so they can sell you into slavery, and competed with equity, okay? And remember, under martial law, equity can do anything it wants. And competed with equity in the case of the essentially equitable quasi-contracts growing out of the principle of unjust enrichment. Surely it would be hard to find a better illustration of the flexibility and power of self-development of the common law, and that's James Barr Ames, The History of a Subset, 3 Select Essays, Anglo-American Legal History, a liar. Black's Law Dictionary, 8th edition, published page 379, a liar's dictionary. Both in Roman and English law, there are certain obligations which were not in truth contractual, but which the law treats as if they were. They are contractual in law, but not in fact, being the subject matter of a fictitious extent of the sphere of contract to cover obligations which do not in reality fall within it. And that's Salmon on Jurisprudence, Sweet and Maxwell Limited, England. constructive quasi-contracts are based solely upon the legal fiction or fiction of law. That's the U.S. citizen. That's the slave, the Sestake Trust. They got to establish that Sestake Trust so they can assault you with one of their so-called contracts. That way they can sell you into slavery. It is well settled rule of law that he who seeks benefits of contract must also assume burdens. Oh, and by the way, jail is a benefit. You get the benefit of going to jail. Voluntary acceptance, and they'll come up with, you get the benefit of getting put to death too. Voluntary acceptance of benefit or transaction is equivalent to consent to all obligations arising from it, so far as facts are known or ought to be known to person accepting. So they assault you with one of their so-called contracts. That's what these Satanists do. That's called bad behavior, folks. A quasi-contractual action presupposes acceptance and retention of a benefit by one party with full appreciation of the facts under circumstances making it inequitable for him to retain a benefit without payment of its reasonable value. So they want to assault you with their jail, sell you into slavery so the whore can collect his royalty. Why do you think they want a Social Security number when you apply for a driver's license or unemployment insurance or a passport or any other benefit? So they can assault you with one of their so-called contracts. A kangaroo court, a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. That's called a bad behavior, folks. There's a whore there and his prosecutor. No, he's a prostituter. He's bought and paid for. They're both bought and paid for. The pig, the vast majority of the disputes that the police initiates on behalf of their employer are also adjudicated by their employer, where the plaintiff, the judge, the antagonist, the police, and the only witness, also the police, all represent the same party, and since no corpus delicti mens rea or acts reus can be produced, doesn't technically qualify to be heard according to its own laws. The state, therefore, is indistinguishable from a criminal cartel. Uniform Commercial Code equals UNIDROIT equals Roman cult. Did you give up your God-given rights for some satanic privileges? Whenever this title creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports of a finding of its non-existence. And so that's UCC 1-206, Uniform Commercial Code. So they assault you with some contract and they sell it on Wall Street. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument are admitted, unless specifically denied in the pleadings. That's why they got to establish the slave. It's only the slave that they can assault this with. If the validity of a signature is denied, the pleadings, the burden of establishing validity is on the permanent person claiming the validity, but the signature is presumed to be authentic and authorized. UCC 3-308. So they forge your signature onto a contract, and then they sell it on Wall Street. This is UCC 8-114, evidentiary rules concerning certificated securities. The following rules apply in an action on a certificated security against the issuer, unless specifically denied in the pleadings. Each signature on a security certificate or in a necessary endorsement is admitted. Okay, so they sell it on Wall Street. There's all sorts of people that have found their criminal case circulated at Fidelity Investments worth millions of dollars, and that's what these Satanist whores do. He, the prisoner, has, as a consequence of his crime, not only forfeited his liberty, but all his personal rights except those which the law, in its humanity, affords him. He is for the time being a slave of the state. They sell you into slavery. And the first order of business of these Satanists is to get rid of the little common law problem, because they'd be put to death for doing this. If a man be found stealing any of his brethren and children of Israel, make merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. This is satanic, folks. This is evil. These people are Satanists. current 13th Amendment. So they had to orchestrate the Civil War so they could facilitate the disappearance of the real 13th Amendment. So these bar members, these foreign agents of the Roman cult, these pigs up here, right there, these pigs could infiltrate the government and seize control. Section 1, neither slavery nor involuntary servitude except as punishment for a crime whereof the party shall have been duly convicted shall exist in the United States or any place subject to their jurisdiction. Yeah, right. They're selling people into slavery. Everything they do is a fraud. A U.S. citizen's a fraud. Commercial papers a fraud. All mortgages are fraud. They get to participate in, they get you because you're asleep at the wheel. They get you to participate in their fraud, and then they assault you with one of their so-called contracts, and then they sell you into slavery. Everybody in prison was sold into slavery. You know, judgments of God are going to come upon this nation, and we are going to deserve it so much. I am telling you, it is coming, and it is going to be ugly. Check out my other videos. Boy, I'm glad that came along because I was getting worked up there. Check out my other videos. Bankster Thieves playlist, Roman cult playlist, bankrupt corporate so-called governments, bar members 1 through 3, do-it-yourself, how not to volunteer for the selective service in the draft, martial laws here, do-it-yourself, no income tax, do-it-yourself, free mail, do-it-yourself, kangaroo courts, now 1 through 15, actually. I got to adjust that, don't I? Canada Border Pigs playlist, bar members and their Satanic Connections playlist. Fraud upon the court. Okay, this is getting to the crux of the matter. This is Bullock versus United States, 10th Circuit, 1985. Fraud upon the court is fraud which is directed to the judicial machinery itself. It is not fraud between the parties or fraudulent documents, false statements, or perjury. It is where the court or a member is corrupted, is influenced, or influence is attempted, or where the judge has not performed his judicial function, where the impartial functions of the court have been directly corrupted. Well, they're all corrupted. They're all Baal priests. They're all Satanists. The judge is not neutral or unbiased. It's a fundamental right of a party to have a neutral and detached judge preside over judicial proceedings. Well, if they're bought and paid for, they're not neutral and unbiased. It's a kangaroo court. So what is your name? What is your birth date? And the answer should be, I neither admit nor deny anything. The burden of proof is on the prostituter to prove his case. Are you trying to fabricate evidence of your U.S. citizen slave? Are you working for the prostituter? Is this a court of law, or is there some fraud upon the court going on today? Are you bought and paid for a clerk? This is Title 28, United States Code, Section 455. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. So they are supposed to recuse themselves when you bring that stuff up. He shall also disqualify himself under the following circumstances where he has personal bias or prejudice concerning a party, has personal knowledge or disputed evidentiary facts concerning the proceeding. He knows that he individually or as a fiduciary or a spouse or minor child residing in his household has a financial interest, that they're getting a royalty, they have a financial interest. Okay, read this whole thing. I'm not going to read it all. Anyways, they have a duty to recuse themselves, but you know, since these whores are sitting there playing stupid, the burden's on you to bring it up. Fraud upon the court is a violation of due process. It's a void judgment. Watch the void judgments video. They're all void judgments. 28 U.S.C. Section 455 is self-executed. Maybe you should recuse yourself before I file a criminal complaint against you there, whore. A kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. They're all kangaroo courts. Brutum fulmen, an empty noise, an empty threat, a judgment void upon its face, which is in legal effect no judgment at all, and by which no rights are divested, and from which none can be obtained, nor binds nor bars anyone. You know, I brought an action in the Texas courts and against FedEx, and FedEx 6, removed it into federal court, and I told the judge I have nothing but contempt for your so-called court. You have an inferior court of limited jurisdiction. Everything you do is brutum fulmen. And, I demanded that he remand it back to state court. And he didn't, but he was real nice. I couldn't believe it. I just about fell over. I figured he was going to dismiss it for sure, and he didn't. But then he ultimately did dismiss it because he wanted to assault me with his rules. And so ultimately he did dismiss it. And what happened was when he did, he brought up the issue that he said that I called his judgments brutum fulmen. It is. This is Constitution for the United States of America, Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. If they're not in good behavior, then it's fraud upon the court. It's bad behavior. It's about time we stood up and told the clerk masquerading as a judge that he's in bad behavior, and he is not a court. A void judgment equals bad behavior. Bought and paid for clerk masquerading as a judge is bad behavior. Fraud upon the court is bad behavior. Denials of due process is bad behavior. Foreign agents of the Roman cult, bar members, is bad behavior. Governments will use whatever technology is available to them to combat their primary enemy, their own population, folks. Time to wake up. For the purposes of this chapter, the term scheme or artifice to defraud includes a scheme or artifice to deprive another of the intangible right of honest services, okay? So it's a felony. If they're in bad behavior and they don't recuse themselves, it's a felony. And so you ought to remind them that you're committing a felony right now. 18 U.S.C. 1346. If destruction be our lot, we must ourselves be its author and finisher. As a nation of free men, we must live through all time or die by suicide. And that's coming from a bar member too. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any inhabitant of any state, territory, commonwealth, or position or district to the deprivation of rights, privileges, or immunities secured or protected by the constitutional laws of the United States shall be fined and entitled or imprisoned not more than a year or both. Now, that's 18 U.S.C. 242, and as a state citizen, you're immune to these pigs, and so they're committing a felony there. They're depriving you of your immunities, secured or protected by the Constitution. 3 things cannot long be hidden: the sun, the moon, and the truth. If 2 or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, position, or district in the free exercise or enjoyment of any right or privilege secured to him by the constitutional laws of the United States, or because of him having so exercised the same, they shall be fined under this title or imprisoned not more than 10 years or both. Okay, so again, let's go back here. What do you think? Do you think maybe this is a conspiracy where these whores are sitting there conspiring together? What do you think? Maybe that's a conspiracy? Hello? And that's the end. Thanks for watching. Have a great day.